Hopefully everybody can hear me. Carl stole a little of my thunder. I was getting ready to brag that today is my 3-week anniversary. 3 weeks ago, right now, I was laying face down in an operating room having Dr. Pat McCormick do a 3-level cervical fusion. When I talked to him beforehand, I said, "How long do you think I'll be off work?" He says, "Typically 6 to 8 weeks. I said, "That sounds a little crazy to me." So I made it my personal vendetta to get back as quick as possible. 1 week after the surgery, I returned to work. His nurse told me I was insane. I was feeling pretty proud of myself. I show up to work, and I'm planning on taking a hearing in Youngstown my second day back. Rob Solt, who thinks he's my surrogate father, says, "You're not going to Youngstown." I said, "The hell I'm not." He said, "You're not going." We did a few rounds. I backed down because he's so much bigger than me. So he sends me to a hearing in Toledo. Get to the hearing, and the issue is continuing use of narcotic medication after 12 years. I just had a 3-level cervical fusion. I weaned myself off of narcotics in 5 days. I'm thinking, I own this hearing. I looked across the table, that claimant sitting there on narcotics 12 years, with all the disgust and disdain I could muster. I told the hearing officer, "I just had a cervical fusion a week ago, and I'm off narcotics already." I then went ahead and made the rest of my presentation, feeling pretty cocky. How could I lose this hearing right now? 2 days later, I got the order from a Toledo hearing officer. "Narcotics granted, keep them going, boys." Welcome back to hearings, Mr. King. So, I'm glad I could be here today. Doing pretty good. I would hardly recommend Dr. McCormick for any cervical fusion you have in your future. Today we're talking about compensation issues as a result of this issue with Archie. I've entitled it "The Good, the Bad, and the Ugly" because there's a little bit of everything in a case like this. The facts, Carl went over them briefly. I'll go over them a little quickly again. Archie was standing behind the garbage truck. He was struck by the truck, driven by Florence, suffered a severe crush injury to both legs. Both of the legs need to be amputated above the knee. Archie ultimately returns to work in a wheelchair. 8 months after he returns to work, come up with a new prosthesis, comes available, Archie undergoes extensive surgery. Archie files for temporary total. Archie's surgery and prosthesis are very successful. Family physician refers him out for a functional capacity evaluation. Doctor states Archie can return to work with restrictions. Good news. Archie never returns to work, at that point anyway. There's a thing out there maybe you're not all aware of. It's called statutory permanent total disability. It's in catastrophic cases like this. There's the RC section that provides for it. Basically provides that permanent total disability shall be compensated in accordance with this statute. In other words, if a claimant has lost the use of both hands, both arms, both feet, both legs, both eyes, or any two thereof, they're entitled to statutory permanent total disability. Well, what's that mean? Archie had both legs amputated. He's lost 2 body parts. Archie is automatically entitled to statutory permanent total disability. There's really nothing you can do. It's automatic. So in other words, Archie's going to be able to collect permanent total disability for the rest of his life. And employers in the audience might think, boy, that's a hell of a windfall. If you just lost both legs, you probably wouldn't think so. This is the part of the one of the part of the statute that really is to compensate someone for catastrophic injuries like this. So if you have a claim where someone loses an eye and a leg, 2 legs, hand and a leg, any combination, they're automatically entitled to statutory permanent total disability. The only time you can really litigate something like that is when you get into the loss of use part of it. Because what does that mean? Say they lost a leg and they've lost some of the use of their hand. Well, the question is if they lose the total use of their hand. That's the question. It can be between getting statutory permanent total disability the rest of your life and not getting it. So it could be a big money question. So amputations are pretty clear. Loss of use, not so clear. Vision, not so clear. So you get into those situations, it might be worth litigating. What's the good part of something like this? Statutory permanent total disabilities, like I said, from a claimant's point of view, is to award them benefits for a catastrophic injury. That's good from the claimant's point of view. However, despite the fact that Archie's entitled to statutory PTD, he can still return to work and earn his full wages. And a lot of employers are not aware of that. They think, so he's been awarded statutory PTD, he's done. They can return to work. They can return to work with you. They can return to work with somebody else. And even if they return to work with somebody else or you, they're still going to get their statutory permanent total disability benefits. So some people say that's a heck of a windfall. You can argue that if you want, but that's the law. They can return to work, earn full wages, while they're getting statutory PTD benefits. What's the bad part about it? By the way, I'm hoping you other people have seen this movie besides me. I just watched this movie again last weekend getting ready for this. It's one of the best cheesy spaghetti westerns you'll ever see in your life. If you haven't seen it, how can you not love Clint Eastwood? He says about 4 words in the entire movie. He was the original Sylvester Stallone, by the way. You can say like 3 words in an entire movie. A claimant who's receiving statutory PTD benefits may be able to get TT if he returns to work and subsequently becomes disabled. Thinking, oh, come on now. This is where you really get into a gray area. There's a case, State Ex Rel Bennett. Basically, the facts are, claimant had surgery for an amputation. Claimant was awarded statutory PTD benefits. At the time he got the statutory PTD, he had not yet returned to work, and he was receiving TT because of the injuries. Claimant's TT ultimately was terminated when he was awarded statutory PTD benefits. Claimant returned to work. There was no medical determination that he reached MMI. Industrial Commission goes to hearing. They never really address whether he can get both benefits at the same time. But TT was terminated. Court of Appeals in that case specifically stated, and this is where it gets a little murky, the facts of this case did not involve a scenario in which a claimant is awarded statutory PTD, returns to work, and then suffers an exacerbation of some injury that temporarily makes him unable to work. Under such circumstances, the payment of temporary total compensation arguably might not be inconsistent with an award of statutory PTD benefits. That's the language that scares the heck out of me. What the court's saying is, although this issue truly isn't in front of us, we can see a scenario where someone's receiving statutory PTD, returns to work with you or somebody else, becomes temporary and totally disabled. Now he's getting statutory PTD and temporary total. It could happen because the court opened the door. Court Bennett did not specifically find he could get them both, but what they said is it's arguably not inconsistent. I've yet to see a claimant's attorney jump on this, but it's going to happen. It's going to happen. It's not a common situation, but most employers that I represent have 1 or more statutory PTDs. It happens in manufacturing facilities or anywhere. So if you've got one of those, just be cognizant. If you bring them back to work, you run the risk of ultimately paying them TT. This guy was great in the movie, by the way. He really is ugly. If you're an employer and you return employees to work who's getting statutory PTD, that's fine, and it's usually a good thing for these people to return to work. Become a useful member, performing a job. It's got to be great for their mental health, everything else. But like I said, beware. If you do return them to work, it is possible they're going to get statutory or a temporary total at some point in the near future. Example, you got somebody who's lost both legs, returns to work in an office setting. They're at work, another employee somehow knocks their wheelchair over and they suffer a low back injury. They become totally disabled. In that situation, despite the fact that you were being nice as an employer and you returned this person to work, they might get that statutory permanent total disability in addition to TT. So they're going to be getting double the benefits they would have gotten had you not brought them back to work in the first place. In Archie's situation, despite the fact Archie's received statutory PTD due to the double amputation, it could be possible for him to return to work and get temporary total if he suffers a new injury. Shift gears a little bit to voluntary abandonment versus temporary total compensation. As we said in the facts, Archie had a functional capacity evaluation. It was determined he was able to return to work with restrictions. Keep that in mind. Archie never returned to work. Does the fact that Archie never returns to work prevent him from getting TT? Well, we'll find out. Voluntary abandonment, as you're probably aware, precludes an employee from getting temporary total compensation. Voluntary abandonment is a very complex issue for any of you that deal with workers' comp. It's probably one of the most complex issues we deal with day in and day out. It's very fact-specific to each claim. If voluntary abandonment is found in a claim, it can save an employer tens of thousands of dollars because it prevents you from ever paying TT in that claim, at least until they get a new job from which they become totally disabled. Voluntary abandonment's a very good thing. Ohio law provides temporary total goes to an employee that is prevented from returning to his former position of employment, but it must arise from basically a condition that's allowed in the claim. However, if that claimant never returns to his job, some pretty significant questions arise, because your eligibility for TT really depends on whether your inability to work was injury induced. In other words, is he not coming back to work because of the allowed conditions in the claim? If a claimant's departure from employment is related to the injury, it's not necessary for the claimant to first obtain other employment before it's precluded that he's abandoned the entire workforce. And this is where it's going to get sticky, because temporary total compensates an individual for the loss of earnings while the injury lasts. And so you stop and think about that for a sense, it makes sense. The whole theory of temporary total is, I have an injury prevents me from working, I get paid while I can't work. However, what do you do when you have a situation when that same worker makes a determination, I'm not coming back? Now, I'm making the voluntary decision, I don't want to come back. In essence, he's voluntarily abandoned the labor force because he's decided he's not returning to work. Got a case that deals with this, fortunately, pretty recent. Facts in the case, claimant was injured in 2005. His claim was allowed for neck and back conditions. Claimant received TT until 2008 when there was a finding of MMI. In 2013, claimant underwent surgery for the cervical spine conditions and requested a new period of TT. However, the critical thing in this case is the claimant had actually applied for and been receiving SSD benefits as well as union disability benefits since 2006. And he continued to receive those after he had requested temporary total. Claimant initially made one attempt to return to work sometime in 2008, but after that, record's pretty clear. He never tried to come back to work for 5, 6, 7 years. So think about that for a second. You've got a claimant who's applied for and received SSD. union disability benefits, been sitting at home for 6, 7 years, happy as a clam, getting his money. Now he has surgery and wants you to pay him TT on top of everything else. Court held in that case that his eligibility for TT depends not only on whether the claimant's unable to perform the duties of his former position of employment, but also, and this is the key part, whether he wanted to be a continued part of the active workforce. The issue of whether he was had permanently abandoned the entire job market is a factual question you got to answer in that claim. And you got to look at what did the claimant intend to do. In this case, he was receiving disability benefits and hadn't even looked for a job in years. Evidence here, because the claimant had gotten an FCE, he was capable of returning to sedentary work, but never made an attempt to return to work. Claimant was ultimately denied TT, win-win for the good guys. In this case, Archie, his prosthesis surgery was very successful. FCE said he could return to work. Archie was initially happy getting his statutory PTD benefits, never made an attempt to return to the workforce. Stop and think about it. If Archie does at some point request TT, you can make the argument he never made an attempt to return to work. In essence, he has abandoned the entire workforce and he's not entitled to TT. That's why you can't lose track of some of these claims. I mean, many times I've seen employers, you get an old claim, someone's on benefits, and they just sort of fall off the radar. Something like this, you got to keep an eye out for them. It just makes sense that an individual must be a part of the workforce if he's going to receive TT, which is a benefit to compensate people who are no longer able to work. If he's abandoned the workforce, there is no loss of earnings. That's about as ugly as you're going to get, I think. So, I don't know if anybody has any questions about that, but they're holding up a sign that my time's about over, so thank you very much.